The Honorable Court is now in session, presided over by the Honorable Judges present here. We have Team Penguin for Petitioner and Team Woodpecker for Respondent. Team shall never disclose their identity in any of their submission. Each team will be given 40 minutes to present their oral pleadings. The team can reserve 5 minutes for rebuttal and surrebuttal within the 40 minutes. There will be 5 minutes time extension for oral submission at the discretion of the Honorable Judges. Submission of compendium to the judges must be made only through the court officers. The petitioner may commence the arguments with the leave of this Honorable Court.
May it please the court. I'm appearing on behalf of the appellant in the particular case of Planet Work Tech versus Green Rotar. Lordships, may it please the court. Well, I'm appearing on behalf of the appellant in the particular case between Planet Work Tech versus Green Rotar with the intervener as an NGO, Your Lordship. Lordship, I will be dealing with issue 4 and 5, whereas my co-counsel will be dealing with issues 1, 2 and 3. May I proceed with the fact of the case, Your Lordships? Obliged. Aryavata is a nation with a staggering population of around 1.4 billion, and the plastic waste management of the nation is pretty poor, that it amounts to 1/5 of the entire planet's plastic waste generation, Your Lordship. Seeing this is a huge opportunity, a particular company, namely Planet Work Tech, has invented a particular machinery which is capable of recycling the plastics in an innovative way, Your Lordships. It hit the market on 2018 and it got its patent on 2020. And a few months after that, another company, namely Green Rotar, introduced a particular product which is so similar to that of the Planet Work Tech. After digging deep down, they found that their patent was indeed infringed. They filed the infringement suit in the district court, where the court held that it was infringed and allowed a injunction and compensation for the Planet Work Tech, Your Lordship, against which the Green Rotar has approached the Honorable High Court, which stayed the injunction. Agreed by that, the Planet Work Tech, that is the appellant, has approached the Honorable Supreme Court regarding the stay, Your Lordship. In meanwhile, an NGO, an environmental NGO, intervened in this particular proceeding, stating that the particular invention made by the appellants should be brought into public domain, Your Lordship, as it directly concerns the right to clean and healthy environment. So, Your Lordships, if you are clear with the facts, may I move on to the arguments of issue 4, Your Lordships. Before stating that, Your Lordship, we approached this Honorable Supreme Court through the jurisdiction provided us in the Constitution, Article 136, which is special leave petition. We are applying for special leave from the order of the Honorable High Court to that of the Supreme Court, Your Lordships. Your Lordships, to start with the argument of issue 4, which concerns the intervention of the NGO in this particular proceedings, it is most humbly submitted before this Honorable Supreme Court that the intervention made by the NGO is not maintainable in law, Your Lordship. Lordships, we, the appellant, has obtained patent for our particular product, Your Lordship, which is being safeguarded by the Patent Act, Your Lordship. And I would like to state a particular legal maxim which goes by expresso unius exclusive altitus. If a particular law states the explicit certain elements, it is also to be understood that the things which are excluded are made deliberate, Your Lordship. In the particular Patent Act, the rights of patentee are provided under section 48, the co-owners is provided under section 50, and the licensee, the compulsory licensee, is also provided a particular provision through which they can indulge their particular stand in the case between the infringement, Your Lordship. Thus, the Patent Act exclusively states that patentee, co-owners and licensee are only to be the part of the suit for infringement, Your Lordships. Thus, this particular act being a conclusive one, deliberately left out any third party to intervene in proceedings which concerns the infringement of patent, Your Lordship. Moreover, Your Lordship, this Honorable Supreme Court, as this particular case is civil in nature, can add or can remove any party during the proceedings through the provision in Civil Procedure Code Order 1 Rule 10 subsection 2, Your Lordship. This Honorable Supreme Court has interpreted this particular provision in the case of Ramesh Kundanmal versus Municipal Corporation, Your Lordship. In our compendium, flag A3 states the interpretation of the Honorable Supreme Court. As of which they stated the court can add parties if they are necessary or proper to the particular case, Your Lordship.
Counsel, this court needs a clarification, and you are challenging the validity of impleading application filed by the NGO.
Indeed, Your Lordship.
Now, maybe knowing Article 142 of the Constitution of India,
Indeed, Your Lordship.
and the Supreme Court is having a bounden duty to render complete justice to the society.
Indeed,
When
Your
the
Lordship.
Supreme Court is having a duty to render complete justice to the society, how can we avoid a NGO which is fighting for the cause of the people not to be implemented? Is it not? Supreme Court is having a duty to do complete justice.
Well, indeed.
So, the NGO is having every right to put forth their plea before the court.
Well, indeed, Your Lordship. But NGO can intervene into this particular core objective in other courses, Your Lordship. This particular case, which is before the Honorable Supreme Court, concerns the patent infringement, Your Lordship. If the very objective of the NGO is to intervene in this proceeding, they can take recourse to the Your Lordship. They can file for a revocation of patent, Your Lordship, according to section 64. They can also file for compulsory licensing, Your Lordship. As we got our patent in 2020, as of today, it's well been more than 3 years. Thus, they can very well apply for a compulsory licensing, Your Lordship. Through that way, our rights will be protected by the Patent Act. Whereas, if the particular objective is to be noted by the Honorable Supreme Court, the Supreme Court can very well issue a direction to the patent officer to provide compulsory licensing, Your Lordship. The only contention of the appellant is that they cannot intervene in a private proceedings between two parties for intervention of apologies, Your Lordship, in the proceedings of infringement of patent, Your Lordship. That is our very contention. Thus, their intervention is not maintainable, Your Lordship. Moreover, Your Lordship,
Whether an environmental issue is just a private matter or concerned with the public interest.
Your Lordship, as far as this particular case is concerned, the nucleus of this case revolves around an invention made by the appellants, Your Lordship, which is a recycle machine. Your Lordship, the very objective of the Patent Act is to provide monopoly for disclosing the accounts of the particular invention after 20 years, which would automatically become a part of the public domain, Your Lordship. This was also reiterated by a Honorable Supreme Court.
Our state is a social welfare state, is it not? Salus, populus, suprema lex.
Indeed, Your Lordship.
Welfare of the people must be given more priority
Well, indeed,
than
Your
the
Lordship.
private interest.
Indeed, Your Lordship.
Yes.
Your Lordship, if the contention of the NGO is that if this particular invention is the only one in the entire nation which can recycle the plastic, we would very well ourselves provide this to the public, Your Lordship. But that is not the case here. Our invention is just a superior version which doesn't need pre-segregation, Your Lordship. That is the only innovative thing that we included in our invention. Thus, Your Lordship, if the very intention is to provide a right to clean environment, Your Lordship, with the population of 1.4 billion and millions of people being unemployed, the reason stated for the previous conventional ways through which already the nation has been recycling the plastics, the reason stated is it needs more manpower, Your Lordship. This cannot be stated with a country with a population of 1.4 billion.
How many patents involved in the particular problem?
Lordship, a singular patent regarding the recycle machine, Your Lordship.
Recycle machine.
Indeed.
What is the purpose of patent was confirmed?
Your Lordship, we received patent to disclose the particular invention to the patent office and not to any others, Your Lordship. Thus, we are being protected by the Patent Act.
Okay. So as a social state, what our brother judge was mentioning, is it not a duty of you to provide the cleanliness of the environment?
Well, Your Lordship, if we were an NGO, we would have done it. But we are an incorporated company which works for profit motive, Your
So
Lordship.
company has no legal responsibility to take care of environment.
Well,
Is
we
it?
indeed have, Your Lordship. Our inventions are directly being bought by the municipalities, Your Lordship. As per the fact, around 10 products has been ordered, 15 products has been ordered by the municipalities, Your Lordship.
Okay, second clarification during your argument, the learned counsel mentioned the conventional practices of disposal of plastic. So according to your understanding, when the plastic rules were framed? Plastic rules were framed when?
Well, Your Lordship, I will answer that in the course of the argument, Your Lordship.
Right. So when there is a rule which is framed by the sovereign state, is it not a duty on the part of a state to use the technology whatever the exclusive marketing right is conferred to the patent holder?
Your Lordship, as I stated earlier, Your Lordship, our invention is not the only one that can provide the clean environment, Your Lordship. There are conventional ways to do so.
Whether
As-
your patent right is it absolute or restrictable?
Your Lordship, it is restricted, Your Lordship.
Okay, what all grounds it could be restricted?
Your Lordship, they can apply for a compulsory licensing and the
Who
center.
can apply?
Any person, any interested person can apply for a compulsory licensing,
Which
Your Lordship.
section of which act says they have to
Lordship,
apply for a
section-
compulsory license?
Section 84 of the Patent Act, Your Lordship.
Please read.
Section 84 states that at any time after the expiration of 3 years from the date of the grant of patent, any person interested may make an application to the controller for the grant of compulsory licensing.
Okay, how many years completed with respect to your e-waste management patent right?
Lordship, we received our patent on 2020, Your Lordship.
Okay,
Thus, it's long due after 3 years, Your Lordship. Any interested person can apply for a compulsory licensing, Your
okay.
Lordship.
Whether NGO includes the person,
Indeed, Your Lordship.
where it is say so?
Well, Your Lordship, the particular term, any interested person is an inclusive word. Whoever concerns about the particular
Would the
product.
NGO come under the category of a person?
An NGO, Your Lordship, it is a legal person, Your Lordship.
Where is the source?
Well, Your Lordship, and a particular company can sue and be sued, Your Lordship, and they do have certain rights, Your Lordship.
So
As of
according
that,
to the learned council, NGOs are company, is it?
not companies, Your
That's
Lordship.
what you are submitting to us.
Your Lordship, an
Company
NGO
can be sued and sue and be sued. We are speaking about non-governmental organization. The simple clarification what the bench want, whether non-governmental organization can be treated as a person. Because you read a section, it says any person can. Would the NGO can be compartmentalized as a person?
Well, the particular the interpretation of the term any interested person also covers companies, Your Lordship. As this is, as
That's
the
what council I am want a specific demarcation. Company we know because
Indeed,
it is a statutory body, right?
indeed, Your
It
Lordship.
has an incorporation procedure. We are speaking about a non-governmental organization. You know well, the same union made restrictions of too many NGOs who are not working for the good interest of nations.
Indeed, Your
That's what the bench want, whether company, NGO can be called as a person.
Well, Your Lordship, it is up to the decision of the Honorable Supreme Court to include them as any interested person as of this particular case is
So
concerned,
according
Your
to
Lordship.
learned counsel, the constitutional bench has a discretion power to accept or not to accept.
Well, indeed, Your Lordship, the Constitution bench has power to do so according to, as earlier stated by the learned judge, according to Article 142, they can
Are
provide
we
complete
conferred with any discretion?
Well,
Brother judge mentioning, in the name of complete justice, we can interpret. But you learned counsel submit, it is a discretion of the court, NGO can be considered as a person.
well, indeed, Your Lordship, the very interpretation of the statutes are coming from the Honorable Supreme Court, Your Lordships.
Yes, counsel, with respect to statute, we can. Whether these NGOs are formed with the help of a statute.
Well, Your Lordship, maintainable, Your Lordship. If Your Lordships are convinced, may move on to the next issue. Obliged, Your Lordship. Well, issue 5 is whether the exclusive patent enforcement undermines Article 21, that is right to clean and healthy environment, Your Lordship. Your Lordships, we as in company are nowhere we are nowhere like denying the right to clean and healthy environment, Your Lordship. We are indeed making products which sole purpose is to clean the environment, Your Lordship. The duty of the government is to provide the clean and healthy environment, Your Lordship. As a company, we are not in any way restricting the government or any other person to do so, Your Lordship. Moreover, Your Lordship, we do also have not only statutory right but also constitutional right, Your Lordship. Article 300A's interpretation regarding the property also includes intangible property as per the interpretation made by the Honorable Supreme Court in the case of Bishwath Prasad Radhesham, Your Lordship. Moreover, Your Lordship, that particular case also
That
states.
property right is given in Article 300A or somewhere.
Well, Your Lordship, Article 300A provides.
Yes, now Article 300A, it is a constitutional right, is it not?
Indeed, Your Lordship.
Now Article 21 is a fundamental right,
Well, indeed, Your Lordship.
is it not? So you want to counter Article 21 by way of Article 300A?
Well, Lordship, I'm not countering Article 21. We are nowhere infringing Article 21, Your Lordship. The claim is totally baseless, Your Lordship. How a particular company, by making a product, infringes the right to clean and healthy environment, Your Lordship. We are being provided with the statutory right to get patent, Your Lordship. Thus, we are enforcing our rights, which is made by the
It
the
is not making, it is utilizing. You have made a machine, is it not?
Indeed,
You have made an invention. Up to that, it is okay. Now, utilization of that invention. There is a part called utility. Utilization of the invention. Whether it is related with the society or only with your company.
Your Lordship, we as a company are providing our products to the society as a large, Your Lordships. As we are a company, we are selling it for a certain amount of money, Your Lordship. Thus, the byproduct of our invention is.
Counsel,
Now,
you
one
are
example I would like to give you, counsel. You know about the cancer vaccine supposed to be invented by Russia?
Well, indeed, Your Lordship.
You know that. And the Russian government, indeed, it is going to give free to everybody in the society. Is it not?
Indeed, Your Lordship.
And just like that, you have invented a machine, and which is supposed to protect nearly 20 lakhs people are dying in India out of environmental issues. So if they are to be protected, it is totally related with Article 21, life of the Constitution. How can you say that it is simply a private right?
Well,
Even though you have invented that.
Well, certainly not, Your Lordship. Lordship, as I stated earlier, the right to clean and healthy environment can be provided in so many other ways, Your Lordship. As far as plastic is concerned, we do have alternate and conventional ways of recycling plastics, Your Lordship. As our particular product is superior to that, it cannot be stated that only our product, if brought into public domain, will provide the right to clean and healthy environment to this entire nation. It is not a substantiate stand, Your Lordship. That is our humble submission, Your Lordships. And moving on, Your Lordship.
Counsel, 1 minute. You made two contradictory statements. One, you said you are the company, you made invention only with a profit.
Indeed, Your Lordship.
Now you are saying, yes, we invented only for the purpose of protecting the people.
Well,
When your enthusiasm is good, why you are not ready to allow the NGO to implead and say, we are very much interested to utilize the essential requirements of a patent?
Your Lordship, we are very welcome to add them as our primary respondent in that particular case, Your Lordship. But this particular case concerns infringement right between
No,
two
when
companies.
they go to the primary respondent in accordance with the patent act, what they will get? Would the
Lord-
company is allowed to, NGO is allowed to get any remedy?
Well, Your Lordship, I would like to state a particular instance, Your Lordship. As the learned judge also stated, during the COVID era, the Pfizer company denied compulsory licensing, Your Lordship. The Indian government persisted for a huge amount of money, Your Lordship. Thus, even in a dire situation, the companies are refusing, and the particular statutes of safeguarding the rights of the companies, Your Lordship. Whereas we are stating that our invention can be made to public in certain other ways, such as compulsory licensing, Your Lordship. In such way, our rights will be protected, and the environment as a whole will also be enriched, Your Lordship. But our contention is that our invention is not the only one which is going to help the right to clean and healthy environment, Your Lordship. If the government and if the NGO has decided so, they have multiple other ways to do the same, Your Lordships.
No, where are the choices for you to say the NGO has a multiple choice?
Well,
Here the fact is very clear. You are the so-called patent holder. Would your patent allow to enjoy the state in the name of sustainability between generations? Would it give an answer?
your lordships, if that is the concern, your lordship,
That is the concern of the fact. That's what your compromise runs.
well,
You go to your compromise paragraph 1 and 2.
your lordships, I would beg to differ from your opinion, your lordship. What I'm stating is that the contention, the primary contention is that if our particular product is made public and as an open source, the entire nation's cleanliness would be upheld, your lordship. But certainly that is not the case. As I'm stating this particular thing again and again because it is very pertinent to our particular fact, your lordship. Our invention is not the only one which is going to upheld the rights, your lordship. It is one of the things. It is superior to that of another. Lordship, it is like stating using a Ferrari for taxi, your lordship. A taxi, like for saving some time. It is not the need, your lordship. There are multiple other ways.
Counsel, again, as our brother judge was asking, I have to get a reference from 300 capital A. Why 300 capital A was introduced?
Well, your lordship, to safeguard the property rights, your lordship. Previously,
Okay, why
which
it was in 1901F?
well, your lordship, the public has overutilized the particular thing and the Supreme Court has held that.
Matter ends.
Well, your lordship, what I'm stating is that our particular right doesn't infringe the right to clean and healthy environment in any particular ways, your lordship. We are just inventing and putting the thing in the market, your lordship.
Counsel, you understood the compromise wrongly. None of the line says your product made a problem with environment. Since you never allowed the people to use your technology, it leads to.
Well, your lordship,
Whether you are having a social responsibility,
Well,
whether the
indeed, your
company
lordship.
is having a social responsibility,
indeed, your lordship.
in what way you are going to fulfill that?
Your
Your
lordship,
invention is there. If you are having a social responsibility, in what way you are going to fulfill that?
your lordships, the company can very well, as a counsel for the company, I can very well interpret it to them and state multiple other ways to take the contract, corporate responsibility, your lordship. But as far as this particular case is concerned, your lordship, it's basically an intervention petition. It is a intervention of infringement of patent rights, your lordship. Well, if your lordships are,
It is not simply the matter of corporate responsibility, not in that sense. Any company may be, any individual may be, any person may be. They are having a responsibility towards the society.
indeed, your
That's what,
lordships.
that's a general policy, is it not?
Indeed, your lordships.
So, whether you are having a social responsibility, you have invented an apparatus to clean environment. Now, if you are not ready to clean that,
Well, your lordships, we are very much ready to share our product through compulsory licensing, through which we can hold the ownership of that, your lordship. And at the same time, the government or the NGO or any other person can utilize our particular product, your lordship. Thus, your lordship, we are like harmoniously constructing both the particular rights, your lordship. We cannot intervene, we cannot like indemnify our particular right by taking it. It is very unproportionate, your lordship. There are multiple other least restrictive ways to do the exact same thing, your lordship. Taking a higher course is not maintainable, your lordship. That is our very humble contention, your lordships. Well, it may
Counsel, already brother judge rightly gave an answer. Your point is how you want to protect your property. So here I am giving a minute. You read the paragraph number 1 of the compromise and answer your issue number 5. Sometime you will get a better clarity.
one second.
Or I'll rephrase my question. What all international environmental instrument made the state to accept how they can confer sustainability for future generation? You confine with issue number 5.
Well, your lordships, in accordance with that, your lordship, and another international convention such as TRIPS agreement also states about the intellectual property rights, your lordship. Well, in that particular thing, Article 27 clearly states compulsory licensing, your lordship. We are very much open to everyone, your lordship. Our very invention's motive is to clean the environment in profit motive, your lordship. Moreover, your lordship, by taking away our right, this exactly goes against the object of the patent right, your lordship. The very reason for existence of patent right is to
Counsel,
incentivize.
patent right, is it absolute or restrictable?
It is restrictable, your lordships.
Fantastic. What all grounds any sovereign state may think of to restrict patent right? which is conferred under the Patent Act 1970.
Indeed, Your Lordship, central government can very well acquire a patent according to section 102, Your Lordships.
Right. Whenever there is an inconsistency between the environmental complaints versus TRIPS, which shall be given a priority?
Well, according to the law of Aryavata, the right to the right to life is considered superior to any other thing,
Fantastic.
Your Lordship.
That's all.
In the same way, Your Lordship, we are not infringing the right to clean and healthy environment of the nation.
No,
Your
you
Lordship.
haven't ladder council. But the technology what you were conferred with a patent is not utilized the purpose. Let me list, please list out the 3 elements of a patent.
Lordships, that concerns issue 1, 2 and 3, which my co-counsel will deal
No
with.
problem. Only I am asking because in order to assist you.
Well-
The elements of patent are novelty,
Origin-
industrial application, then
Ascertainment, Your Lordship.
for a public purpose, right?
Indeed, Your Lordships.
That's what. So whether the technology what is conferred to you is encouraged to use the purpose in which?
Lordship, this particular invention directly relates to public welfare, Your Lordship. As it is a recycle machine for plastics, it very well correlates with the right to clean and healthy environment, Your Lordship. It directly supports the clean and healthy environment and the public utility, Your Lordships.
Okay,
Well, if Your Lordships are convinced with arguments of 4 and 5, my co-counsel will continue with argument 1, 2 and 3, Your Lordships. Much obliged.
Judgments, thereby hindering the business of the appellant only in the December of 2024, Your Lordships. The point that I'm trying to make is that the patent was in existence without any problem for the past 4 years, or in other words, for the 4 years right from obtaining the patent, Your Lordships. So, in order to, in so far as the allegations made by the Greenwater, Your Lordships, in so far as the revocation application is concerned, the only thing that has to be proved before this honorable bench is the infringement, Your Lordships. There should be a prima facie case of infringement. Your Lordships,
Counsel, whether your submissions relating to infringement or revocation.
Your Lordships, the third issue raised by this honorable bench in the instant case is about the revocation, Your Lordships. I'll come to the revocation when I'm addressing the third issue.
You
Okay, because
come-
you club both are.
You come before the court, this court, on Article 136 of the Constitution of
Yes,
India,
Your
is
Lordships.
not? And to come before under Article 136, a substantial question of law must be challenged, is it not? Must have been challenged. Can you say that from the order of the High Court, any substantial question of law is denied by the High Court or not applied by the High Court?
Your Lordships, my submission is that the High Court has erred in granting
Yes, that's
a
what
stay.
I am asking. Then the High Court ought to have erred in a substantive question of law.
Your Lordship, I understand the question that your Lordship is asking, but my Lord, I hereby submit that the High Court has granted only a stay. The undisputed fact says that the High Court has granted a stay. But your Lordship, the High Court, in order to be a question, in order to be a substantive question in the law, your Lordship, the High Court has not gone into the merits of the case. The High Court has only granted a stay. And even then, your Lordships, when we are approaching the Honorable Supreme Court through Article 136, your Lordships, the Honorable Court reserves right to grant special leave and hear the matter, your Lordships.
Sir, is there any compartment called the right to grant special leave after the final outcome? Because as my brother judge was repeatedly asking, what is the substantial question involved? Because 136 categorically says any order. It does not make any compartment call, is it an interim order or final order? What does your say on this?
Your Lordship, I cannot comment on the substantive question of law when the High Court has not gone into the merits of the case, your Lordship. If your Lordship wants me to elucidate on a substantive question of law in the instant case, your Lordship, since there is intervention of the NGO which is also approved by the Supreme Court as of now in the instant case, your Lordships, Article 21, the question surrounding Article 21, right to clean and healthy environment, could be the substantive question of law in order to substantiate the Supreme Court's jurisdiction as under Article 136, your Lordships.
Which line of Article 21 says right to environment is a life?
It is intrinsically present. The right to enjoy a clean and healthy environment is intrinsically present under the Article 21, your Lordship. That's what the Supreme Court has held in the plethora of environmental cases. If your Lordships permit, I would
Continue.
Your Lordships, secondly, irreparable harm has been made to the Planet Work Tech Incorporation in the instant case, your Lordships. Your Lordships shall kindly refer paragraph number 8, your Lordships, of the moot proposition. Your Lordships, 6th line of paragraph number 8. Greenwater secured contracts with 5 major municipal corporations, including several formal clients of Planet Work Tech Incorporation. Your Lordships, there are 2 articles in the instant case, your Lordship. There are 2 articles. One is a patented article for that matter, Bioshredder. And there is another article, namely Trashmaster, your Lordship, which is an infringing article. It does not have a patent. Your Lordships, here, despite having a patent, irreparable harm is being happened to the appellant, your Lordships. The company has evidently lost its client base, your Lordship, as your Lordships now referred to. This spoils the goodwill of the company, your Lordship. It diminishes the goodwill. It challenges the client base, your Lordships. Since it is an incorporation, your Lordships, the economical interest and the commercial interests of the stakeholders is diminished, your Lordships. Furthermore, your Lordships, the company was incorporated in 2008, your Lordships. The company's motive is in line with the economic principles of the state of Aryavardha. Here, your Lordships, despite having a valid patent, that being infringed by a company and then damaging the goodwill of the appellant, your Lordships, the 17 years of excellence
Counsel, you are arguing on which issue?
Issue number 1, your Lordships. Your Lordships, 17 years of excellence of the company is at stake, your Lordships, without being at any fault. Furthermore, I see that your Lordships has raised reasonable questions regarding the public interest, your Lordships. If your Lordships shall kindly refer paragraph number 10 of the moot proposition, your Lordships, the NGO has come into the matter only in the Supreme Court. Your Lordships, there was no public interest view before that, your Lordships. The NGO has come only now, your Lordships. That has to be taken note of.
The only clarification is
Yes.
whether your company is contract with other corporations or stayed by the High Court?
Your Lordships,
actually you are appearing for that
Planet Work Tech Incorporation.
your corporation
Yes, Your Lordships.
entered into contract with the 6 municipal corporations.
Municipal corporations.
Whether that has been stayed by the High Court?
That has not been stayed.
stayed. So it is still there.
Your Lordship,
You can, perform your contract, or you can respect the contract, and you can do that.
Your Lordship,
One thing is, the other side is also permitted.
the point that the court shall take cognizance of the fact that, Your Lordship, the appellants had approached the district court. Your Lordships, the appellants have approached the court, Your Lordship, regarding the municipalities, regarding the contracts with the municipalities. We have lost all those contracts because of the infringement made by the respondents. This is a case of infringement of the patent, Your Lordships. My Lord, Your Lordship had raised questions about Article 142, complete justice, Your Lordship. Your Lordships, all those things are very distant to the instant case, Your Lordships. Your Lordships, the NGO, in our view, Your Lordships, the NGO has nothing to do with the instant case, which is a clear case of patent infringement. Your Lordships.
You take a paragraph from the lines from paragraph 8 of the compromise.
Yes.
Okay.
Yeah.
9th line from the top. What was the submission made by the NGO condemning the patent right which is conferred to you appellant?
In paragraph number 8, Your Lordship.
Paragraph number 10,
10.
line number 9 from the top. The NGO argued
The NGO,
that such technologies, you read.
the NGO intervened in the Supreme Court proceedings alongside Planet Works Tech, thereby ensuring that the issue of patentability.
Now, which paragraph you are reading? Are you reading paragraph number 10?
Paragraph number 10,
Then
line number 10, line number 10.
No, the NGO argued that such technologies. Is it the same compromise?
The NGO argued that such technologies vital
yes.
to mitigating plastic pollution must remain in the public domain to ensure widespread deployment and equitable access. Your Lordship,
Continue and complete. Last line.
and therefore no exclusive patent rights should be granted or enforced. Your Lordship, I humbly submit that, Your Lordships, in cases, even in the case of life-saving cancer drugs, Your Lordship, this honorable court had made only mandatory licensing as the rule. Your Lordships, if the governments think that the invention, patented invention of the Planet Work Tech, for that matter, Bioshredder is the only option to fight with the mixed waste, Your Lordships, then the government is free to buy as many as Bioshredder machines from the appellant company, Your Lordships. The government is free to buy the patented machine, Your Lordship. Furthermore, even if the government wants some other companies to manufacture the same machine with the same configuration, mandatory licensing shall be made as a rule by the government as under Section 84.
The thing is,
Your Lordship,
Conferred, you can institute a proceedings for commercial licensing.
Your Lordships, I understand the question Your Lordship raises, but Your Lordship, the court shall take cognizance of the fact that the appellant had approached the trial court for the infringement of the patent, Your Lordship. The NGO, Your Lordships, it is a misconception, Your Lordship. It is a misconception that the NGO.
Counsel, misconception, it is depends upon what is the substantial understanding you have with your patent act and the infringement. Now we will live with the compromise. The paragraph categorically says the duty of the NGO to support whatever compromise, that paragraph 1 of compromise speak. What is the paragraph 1 of compromise? Go and read. If you want, I am ready to assist.
Full paragraph, Your Lordship.
Yes. The rapid progress has brought mounting challenges in managing municipal and industrial waste, combating pollution and advancing towards sustainable development. The government of Avarta has advanced environmental conservation through laws and blah blah blah. Then the constitution further ensures every citizen's right to clean and healthy environment. When you people are getting a monopoly right of not to use the technology, how the state itself think of to realize its constitutional duty to.
Your Lordships, firstly, Your Lordship, when a patent is granted, Your Lordship, monopoly is offered to that particular patented invention for a very limited period, for that matter, 20 years, Your Lordship. Before that, if it wants to be in the public domain, Your Lordship, in a huge number, there is an option of mandatory licensing. For the question that Your Lordship asked, I shall make two submissions, Your Lordship. Your Lordship shall kindly refer 9th line of the first paragraph. Swatantra Swachhata mission, Your Lordship, it was the mission brought by the government to eradicate the plastic waste, Your Lordships. Now, Your Lordships,
Continue, that's only mission, then continue next line.
and plastic waste management rules compliance programs that have played a vital role in this effort, supported by a diverse client base. Your Lordship, now, Your Lordship shall kindly
Suggest an alternative, how the state may think of to realize its duty to conserve or reduce or eradicate plastic.
Your Lordship, the point number 1 is that, Your Lordship, the appellant company is not polluting the environment.
That's what.
Another,
Brother Judge was asking, since we have a so-called right for 20 years, is it not your duty to accept your responsibility? That sir was adding corporate social responsibility. Do you have or no?
Your Lordship, if government's concern is that, Your Lordship, I already have submitted regarding the rule of mandatory licensing. Furthermore, Your Lordship, the appellant company is ready to make any memorandum of understanding with the local municipalities or the governments for the furtherance of the mission in a reduced cost or a lower cost, Your Lordship. Your Lordship, nowhere the making the valid patent invalid does not solve this problem once for all, Your Lordship. Furthermore, my contention is that, Your Lordship, the appellant company is not polluting the environment, Your Lordships. Furthermore, I hereby submit before the honorable bench is that it is the misconception that the central issue surrounding the instant case is the environmental degradation. It is not, Your Lordship. The central issue surrounding the instant case is patent infringement and not the environmental degradation.
Counsel, again, I don't know why you missed the core of the compromise. The core of the compromise is how could an advance permission which is given referring patent act is going to make a state in a very bad condition.
The fundamental point is, what is the object of patent act or intellectual property rights? Merely to earn money or to invent, earn money and to help the society?
Your Lordship, I'll answer the questions one
If
by one.
your argument is that invention is only for the purpose of earning money, it's okay. But TRIPS agreement or IPR, intellectual property rights, their object is not only assist the individual who has invented, and also to extend the invention to the cause of the society. And in that area, what are you going to do? Because you want to separate that. You simply say that we are no way connected with the social responsibility or society. We are talking about only infringement of the right. But it is totally connected with the society. Perhaps you might have read about Article 3, Section 3B of the Patent Act. Isn't it? If any invention is relating to public interest or regarding the society, something.
Your Lordship, the point number 1 that I wish to make is that, Your Lordships, our invention nowhere affects the public interest or public morality. Your Lordships shall kindly refer second line from the last, paragraph number 4 of the compromise, Your Lordships. Transform waste into valuable resources through sustainable innovation. Your Lordships, this has been the mission of the appellant company. Your Lordship, this particular mission is in line with the Swatantra Swachhata mission and other rules of the central government, Your Lordships. Your Lordships, the submission that I make before the honorable court is that, Your Lordship, the question that I put before myself is that, Your Lordship, has the appellant company erred in going to court for the infringement of the patent, Your Lordships? Point number 1, we have a valid patent, Your Lordships, and that particular patent is infringed by the respondent, Your Lordships. Thereby, we have filed a case in the lower court, Your Lordships. Then, even after the lower court ruling in our favor, your lordships, it was appealed to the High Court, and the High Court has stayed the case, your lordship. Now the issue that I am arguing is whether the High Court has erred by granting a stay, your lordships. The appellant company is nowhere at fault, your lordship. That is the submission that I wish to make before the honorable bench. If your lordships permit, I would move on with the arguments. Lordships, the second submission is that your lordship, the appeal is on principle and there is no fundamental error, your lordships. Your lordships, whenever there is an interlocutory relief by the lower court, your lordships, the High Court only deals with that particular appeal on principle, your lordships. In other words, your lordships, the facts recorded by the lower court is just appreciated by the High Court, your lordships, and the High Court overturns or stays the judgment only if there is a fundamental error or a grave mistake made by the trial court, your lordships. But in the instant case, there is no such grave mistake or fundamental error by the district court, your lordships. For that matter, your lordship shall kindly refer flag number 2 of the compendium, your lordships. In the case of Vander Limited versus Antox India, the Honorable Supreme Court authoritatively noted that an appeal against exercise of discretion is said to be an appeal on principle. Appellate court will not reassess the material and seek to reach a conclusion different from the one reached by the trial court. In other words, your lordships, the judgment of the lower court is not overturned or stayed just because of the fact that the High Court would have ruled contrarily. Lordships, furthermore, I see that Lordship mentioned TRIPS agreement, your lordships. Article 44 of the TRIPS agreement says that any person who has a valid patent in the member countries shall have the option of injunctions whenever the patent is infringed, your lordships. And the state of Aryavarta has ratified TRIPS agreement, your lordships, and we as a member nation have our moral duty to uphold TRIPS agreement as under Article 253 of the Indian Constitution.
Counsel, which article of TRIPS agreement says the state ratified the TRIPS agreement 1994? The council made a submission, the TRIPS agreement was ratified.
Article, not 95, Lord, 44
No,
of the
TRIPS agreement was ratified.
yeah.
So where only I am clarifying with the learned council, which article of TRIPS agreement says the same agreement was ratified?
By the Indian government, your lordships.
Is there any article from a TRIPS which says India got ratified?
That has to be referred to, your lordships.
Please refer and respond.
We will respond during our rebuttal time.
So according to learned council, TRIPS agreement is a soft law or hard law?
Your lordships, it's not a law, your lordships. It's not a
Then
law.
why we have to ratify?
We have Article 253, your lordships.
What does it say? Is it speak about soft law or hard law or both law? Have you come across soft law and hard law approach?
Yes, your lordships.
Okay. What TRIPS agreement is a soft law or hard law?
It's a soft law.
It's a soft law. So therefore ratification.
Yes.
Then which article of TRIPS says? Ask our learned researcher, then you can continue.
Your
Then
lordships,
we'll get an answer.
We'll
Let her research. That responsibility goes to her.
If your lordship permit, I will move on to the second
Please,
issue.
please.
Whether the Trashmaster infringes the core claims of Planetwork Tech's registered invention under the applicable laws of Aryavarta. Your lordships, insofar as the second issue is concerned, I will firstly establish the infringement of the core claims of the valid patent. If your lordships, the compromise, it clearly says about the dependent and independent claims. Your lordships, the core claims of the bioshredder.
Which paragraph of which line says?
Sixth paragraph, your lordships.
Read a line.
Paragraph number 2. 5 independent claims focusing on the bioshredder's mission, core process, apparatus, and 10 dependent claims detailing enhancements including emission control features. Your
The
lordships,
same line continues with last 3. Invention, novelty step and industrial applicability, right?
yes, your lordships. Your lordship, bioshredder missions, core, the 4 important claims mentioned in the facts is that, your lordships, bioshredder mission, its core process, its apparatus, and the emission control features, your lordships. Lordships, Dr. Karan, he submitted a statement. He submitted a report stating that 3 out of 4 core claims of the BIOS reader is violated, Your Lordships. Lordships, if we consider these are the 4 core claims made by the BIOS reader, Your Lordships, if 3 out of 4 is infringed by the trustmaster, then it is a complete infringement of the patent, Your Lordships. Your Lordships, thereby establishing the infringement, Your Lordships, I would like to make my submissions under 3 different rules or doctrines, Your Lordships. Firstly, doctrine of pith and marrow. Lordships, an article.
Which page of the written submission were referred?
In issue number 2, Your Lordships.
Page number, footnote number. Yes, researcher, you can assist. Which paragraph of which footnote number?
Your Lordships, we have detailedly included everything in the written submission, but what I am trying is,
Have you referred these 3 doctrines in your written submission?
it has been referred to, Your Lordships.
Which page, which footnote number? Because we should not accept whatever is there, is not there in your written submission. It's an instruction which is given to us.
Your Lordship, we will take this question also and we will refer to at the end.
Your researcher.
Your Lordships, having established the infringement of the core claims by the trustmaster, Your Lordship, doctrine of pith and marrow. Your Lordship, this particular doctrine stipulates that an article cannot have all the core elements of another patented article and make some minor changes and get away, Your Lordships. That is the.
Is there any section from Indian Patent Act supports for the same pith and marrow doctrine?
Your Lordships, yes, Your Lordships.
Section. Because we are bound by the law made by our parliament.
Your Lordships,
In something from US or Europe. Are you open?
Your Lordships,
Open section and respond.
not just sections, Your Lordships. Evergreening was detailedly discussed in Novartis case. Pith and marrow was very detailedly discussed in Raj Prakash versus Mangatram Chowdhury. It is to be referred in flag number 4.
Particular case was decided referring which section of Indian Patent Act 1917.
It is a doctrine propounded in the very same case, Your Lordships.
Yes, counsel. For a case, there should be some section question. No. Which section of Indian Patent Act?
Your Lordship,
Evergreening patently everybody know, right? Then which section of Patent Act was referred?
Lordship, doctrine of pith and marrow.
Any grounds are given in the Patent Act regarding infringement, and what circumstances something can be called as infringement like that? Any provision is there in the Patent Act?
That's what counsel has to assist us.
Your Lordship, 48, section 46, 48 grants exclusive rights so that no other companies or no other individuals can replicate the same. They cannot sell it, they cannot export it, Your Lordships. Exclusive rights are granted. Your Lordships, but in order to prove the infringement of the patent, Your Lordships, we rely on the doctrines and rules propounded by the Indian judiciary. That way, if Your Lordships permit, I will quickly make my.
Okay, fine. So how many judges have decided the same case?
Your Lordship, in that particular case, Your Lordships, it was a single judge bench. Your Lordships, my submission is that, Your Lordship,
You know well, 141 will not apply.
even when my co-counsel.
Bringing a single judge bench, how it would cover all constitutional bench?
Your Lordships, I am of the view that any authority that I cite before a constitutional bench is that, Your Lordship, it carries only reference value. Your Lordship, it does not squarely binds the judges, Your Lordships. I am making it evident that the infringement has occurred, and the Indian judiciary has time and again reiterated that the infringement of patent cannot be allowed to get away with. That is exactly what I am trying to argue, Your Lordships. Your Lordships, in that particular case, Your Lordships, the court ruled that a person is guilty of infringement. Flag number 4 of the compendium. A person is guilty of infringement if he makes what is in substance the equivalent of the patented article, Your Lordships. Secondly, Your Lordships, doctrine of equivalence. Doctrine of equivalence is that, Your Lordships, it was once again, it is a principle which almost mirrors the doctrine of Pitt and Marrow, Your Lordships. This particular case was in 2024, Your Lordships. The Delhi High Court once again reaffirmed doctrine of equivalence, Your Lordships.
Counsel, we are in a Supreme Court.
Your Lordships,
Cite a judgment where it will literally think of us to. Because you already cited ground 136 made you to exhaust the jurisdiction. When you cite a High Court judgment, then what's the point then? Tomorrow it will come the same case again we have to. Take a case where you think. That's what I'm asking you to gather a particular article from a consti and have a confidence and a cite. So go to final issue,
Your Lordship shall kindly refer the Raj Prakash versus Mangatram Chowdhury, Your Lordship.
what's the footnote number?
It is in the compendium, number 4, Your Lordship, flag number 4.
Referred as a footnote in your written submission.
Your Lordship, it would have been referred to, Your Lordship.
Give it to your researcher. Check.
Then if Your Lordship's permit, I will move on to the third issue. And
Yes, go final issue.
the third issue is that whether the patent granted to Planet Works Tech is valid and enforceable in view of counterclaim for revocation filed by Green Rod. Your Lordships, I hereby submit that the patent granted to Planet Works Tech is valid and enforceable, Your Lordships. For that matter, Your Lordships may kindly refer to the last 3 lines of paragraph number 5
Paragraph 5 of
of the proposition.
Comrade.
Over nearly 2.5 years, the team conducted hundreds of laboratory experiments, pilot plant trials, and computational simulations to identify the optimal process design. Your Lordships, at the outset, Your Lordships, there is an invention, Your Lordships. If there is no prior art, it is an invention as defined under Section 2, Subclass 1J of the Indian Patent Act 1970. Your Lordships, only the invention gets a patent, Your Lordships, and therefore we have applied for a patent and obtained a patent, Your Lordships. If there is a machine which essentially does the same thing, Your Lordships, it substantially functions in the same way, it does the same function and delivers the same output, Your Lordships, it is infringing the patent, Your Lordships. It is infringing a valid patent. It is not an invention, Your Lordships. If there is a machine which mirrors the process, the core claims of the bioshredder, it is not an invention and a discovery. Contrarily, Your Lordship, Sections 3 Subclass D says what cannot be an invention. See, 3 Subclass D says that mere discoveries are not invention and which is not an invention cannot be patented, Your Lordship. As Your Lordships rightly mentioned several times, an invention is an invention only when 3 things are proved before the bench, Your Lordships. That is novelty, inventive step or non-obviousness, and finally industrial applicability, Your Lordships. In the instant case, Your Lordships, bioshredder comes with an unique 3-stage thermal mechanical process, Your Lordships. That is the novelty which solves the problem of segregating mixed waste, Your Lordships. So the novelty is that since there is also no prior art, Your Lordships, the prior art allegations made from the Germany was eradicated with the counterclaims by the appellant company, Your Lordships, and only then the patent was granted. So novelty is hereby proved, Your Lordships, and therefore moving on to the next thing, Your Lordships, it is non-obvious, Your Lordships.
The respondent says that in paragraph 8, your invention is only something standard engineering norms, nothing more.
Your Lordship,
If it is some standard engineering norms only, then no question of prior art.
Your Lordship, my humble submission is that the defense of standard engineering norms does not apply in the instant case, Your Lordship. Your Lordship, if it is standard engineering norms, Your Lordship, lordships, it can be understood that they are saying that it was unintentional. Any similarities are unintentional. That was the statement made by Mr. Rajesh Kapil, the CEO of the Respondent Company of Lordships. In his statement, in the move proposition, it has to be taken note that he does not rebut similarities. He agrees that there are similarities, but he denies infringement, Your Lordships. I submit before the Honorable Court that even if it is unintentional or even if it is standard engineering norm, Your Lordship, when the patent was applied by the appellant company, the invention goes on record to the public. When it is on record in the public, Your Lordships, I'll complete it. I'll sum up in a minute. Lordship, when it is on record, when the invention is on record, Your Lordships, even if it is unintentional, Your Lordships, it cannot be copied and it would amount to infringement even then. Lordship, furthermore, it has solved the long-standing problem, Your Lordship, under the novelty and non-obviousness that it is not obvious to any person who is skilled in the art. It proves the inventive step, Your Lordship, and it is needless to prove the industrial applicability since we are in the business for past 4 years, Your Lordships. And finally, Your Lordships, I have specific points to rebut revocation under section 64, Your Lordship. If there is anything else, I'll convey during my rebuttal, Your Lordships. And the fine. Wherefore, in light of the facts, circumstances of the present case and the arguments advanced, it is most humbly prayed that this Honorable Court may be pleased to set aside the order of the Honorable Chalukya Des High Court granting a stay and thereby restoring the injunction against Green Rotor Private Limited from manufacturing, selling or distributing the Trashmaster machines. Declare that Green Rotor's Trashmaster machine infringes the core claims of the appellant's registered invention, the Biosreader. Affirm the validity and enforceability of the appellant's patent and dismiss the counterclaim for revocation filed by Green Rotor Private Limited. Hold that the intervention sought by the Earth First Foundation in the private infringement action is not maintainable in law. Clarify that the enforcement of the appellant's patent does not violate the constitutional right to a clean and healthy environment, nor Aryavardha's international obligations. Pass any such or other or further orders as this Honorable Court may deem fit in the interest of justice, equity and conscience. Lordships, I have one further request to Lordships to the bench. Your Lordships shall, in furtherance of section 115 of the Patent Act, Your Lordships, read with order 26 of the CPC, Your Lordships may consider forming a technical committee of independent experts, and based on their report, Your Lordships shall decide, even though the case is highly favorable to the appellant, Your Lordships. Lordships may consider. It was an honor appearing before this bench, Your Lordships. Thank you.
The council seeks permission to approach the dais. Much obliged. Warm greetings to the warm greetings to the honorable bench. It is our privilege to appear before this honorable bench as respondent for Green Rotor. The council seeks permission to address the bench collectively as Your Lordships. Much obliged, Your Lordships. If the bench is satisfied with the facts, the council seeks permission to proceed with the issues. Much obliged, Your Lordships. Your Lordships, Aryavata is a vast democracy and rapidly industrializing nation facing significant challenges in managing plastic and municipal waste, Your Lordships. Aryavata contributes 20% of world's total plastic waste, Your Lordships. Your Lordships, Baranitv in mid-2018 launched Project Phoenix, developed the machine Biosreader, a 3-stage thermal product, Your Lordships. Your Lordships, on 2020, Baranitv Court of Aryavarta, Your Lordships. Your Lordships, Earth First Foundation, an NGO, intervened in Supreme Court proceedings contending public rights to clean environment was indirectly compromised. Your Lordships, here the Council would like to clarify the submissions made by the appellant, Your Lordships. Your Lordships, section. Your Lordships, it is regarding the jurisdiction, Your Lordships. Lordships, I, Speaker 1, will be dealing with issues 1 and 2, and my co-counsel will be dealing with issues 3 to 5, and my researcher will be assisting us, Your Lordships. Much obliged, Your Lordships. Your Lordships, Section 104 of Patent Act. If any counterclaim is placed for revocation by defendant, it should be transferred to the High Court, Your Lordships. So, the District Court of Aryavarta had no grounds in determining the issue, Your Lordships. In the fact proposition para 9, it is clearly stated that the counterclaim for the revocation of patent was filed, Your Lordships. And also, Your Lordships, the appellant has approached this.
Was it mentioned anything between District Court and High Court? The compromise lines. It does not speak, no?
Your Lordships, in
Then
para
no-
9,
Was there any clarification on the same by the organizing committee?
Your Lordship,
It is not. Then
No,
don't. Then directly jump to the Supreme Court.
indeed, Your
Don't
Lordships.
introduce any new facts.
Indeed, Your Lordships. Your Lordships, the Council seeks permission to move on to the issue 1. Much obliged, Your Lordships. Whether the High Court was justified in granting a stay permitting Green Rota to continue its sale, Your Lordships. Your Lordships, the respondent most respectfully submits before this Honorable Supreme Court that the impugned order passed by High Court granting a stay allowing the respondent Green Rota to continue the sales of Rashmaster is wholly justified, Your Lordships. Your Lordship, the Council says it is legally sound. Your Lordships, before this Honorable bench, the respondent stands not an infringer, Your Lordships, seeking unfair advantage, but an innovator defending the fruits of independent research, technological improvement, and fair market competition, Your Lordships. Your Lordships, the Council seeks permission to address the issue when one with 4 folds, Your Lordships. Much obliged, Your Lordships. Your Lordships, the first fold, requisite prima facie from appellant. Your Lordships, firstly, the Honorable High Court has correctly applied the principles and rightly found that the Planet Work Tech has failed to establish a prima facie, Your Lordships. Your Lordships, the legal maxim, Cambodum, ex injuria, sua nemo habeat debet. No one should gain an advantage from their own wrong, Your Lordships. Your Lordships, the Honorable Court cannot presume patent validity where defendant mount a genuine validity challenge of the patent, Your Lordships. Your Lordships, under section 104A of Patent Act 1970, the burden of proof in case of suits concerning infringement is directed to defendant only when there is an infringement, Your Lordships. Here, Your Lordships, our content is there is no infringement, Your Lordships, and we say the patent given to the appellant itself is invalid, Your Lordships. Your Lordships, the Council seeks permission to highlight 2 paragraphs, Your Lordships, para 5 and para 7 of the moot proposition, Your Lordship.
Counsel, what all grounds in which you are substantiating the patent itself was conferred by the registrar of patent is not valid?
Indeed, Your Lordship. Your Lordship, para 5 of the moot proposition and para 7, Your Lordship, we say, first I would say that our invention does not infringe, then I move on to say that the patent granted to them is invalid, Your Lordship. So, para 5 and the para 7. Here it says that
What are the grounds the Patent Act 1970 says? Any patent can be called as an invalid patent.
indeed, Your Lordship, the section 64, Your Lordship, the section 64, lack of novelty, lack of inventive step, non-proof of substance matters.
The learned counsel for the appellant categorically proved all the elements.
Indeed, Your Lordship.
Then how you will say whichever point they made with respect to novel, non-operationist and industrial application, where you found a omission by the registrar of patent when they are granting a patent to the same.
Indeed, Your Lordship, this is related to the third issue and my co-counsel will be defending
Counsel,
those. Indeed,
you
Your
made a
Lordship.
submission I'm
your
not
lordship.
questioning the infringement. I'm
Indeed,
questioning
your
the patent which was given was invalid.
Indeed, your
That's
lordship.
what the learned bench required.
Indeed,
Sorry,
your lordship.
the bench required clarification from you, counsel.
Indeed,
When you
your
feel it is a third issue, then why you are bringing when you are arguing a issue number 1?
Indeed, your lordship. We are saying that in issue 1 and 2, the infringement itself has not happened and the patent granted is not valid, and this particular patent
Patent is not
invalidity-
valid on what ground? Justify a ground from the act or any
Indeed, your
maxims or doctrines or judgments which you have.
Indeed, your lordship. The invalidity of the patent is on the grounds of 64 lack of novelty, your lordship, and also, your lordship, the council seeks permission to get the.
One clarification.
Indeed, your lordship.
Para 5.
Indeed, your lordship.
See, the Planet Works, okay,
Indeed, your lordship.
they developed this,
Indeed, your lordship.
assembled a cross-functional research and development team of mechanical engineers,
Indeed, your lordship.
chemical engineers,
Indeed, your lordship.
environmental scientists, and software programs.
Indeed, your
With
lordship.
all this research
Indeed, your
and
lordship.
hard work,
Indeed, your
putting,
lordship.
burning their midnight oil,
Indeed,
they
your lordship.
developed this particular apparatus.
Indeed, your lordship.
Now, as far as this paragraph 8,
Indeed, your
this
lordship.
Green Rotor Limited, is
Indeed,
not.
your lordship.
By some consultation with German consultants
Indeed, your
and
lordship.
standard engineering objects they have
Indeed, your
developed like that, it is given. That is your party, your
Indeed,
client.
your lordship.
So, what hard work or what intellectual thought put by your client regarding developing this?
Indeed, your lordship. Your
They
lordship.
have done the research.
Indeed,
They
your
have
lordship.
a team is there
Indeed, your
consisting all experts.
Indeed,
But
your
do you have any such experts as
Indeed,
far
your
as this moot proposition is concerned?
Indeed, your lordship. Since they are trying to prove that there is an infringement, they have showcased the expert details, your lordships. But the Green Rotor also has such expert in the moot para 7, your lordships. I would say Green Rotor Private Limited, a younger competitor, announced the launch of its own mixed waste processing machine, the Thrashmaster, at the Aryavarta Waste Expo in Dilipur. Your lordships, the word own itself says that it is a new product that is launched out of greater efforts made by the Green Rotor, your lordships, and also, your lordships, it also says that it has got consultations from various experts, your lordships, and also, your lordships, when it comes to the Planet Works, they have also consulted their own experts, and it is a very old company, your lordships. Being a young competitor, we have invented a new machine which is totally different from the biostator, your lordships. That is what the council is trying to say by comparing.
Product is a new invention.
Indeed, your lordships. Indeed, your lordships. Your lordships, first we would say that our product is totally a new invention by citing the paras 5 and 6. In 5, it says that the Planet Works machine, that is converting mixed grade plastics, your lordships. When it comes to our machine, para 7, it is mixed waste processing machine, and it is a collection of wastes, not only the plastic waste, your lordships. So this itself proves that our core is totally different. It is very depth, and their core lies only to the plastic, your lordships. Also, your lordships, in para 8, it is very clear that we have independently developed with input from German consultants. The word independent also proves that we have invented a new machine, which is very evident from the fact, your lordships.
Where is it? Independent.
Para 8, your lordships. Your lordships, the 5th line, Thrashmaster was independently developed with input from German consultants. And that similarities were due to standard engineering norms. So we are trying to say that our machine is totally different from the Planet Works machine, and it is very evident from the fact that the two machines are not similar, your lordships. So there is no point of infringement. Your lordships, moving on to my issue, first fold, your lordships, under section 104A of patent Patent Act 1970, the burden of proof lies with the defendant only when there is an infringement, and from very fact proposition we have proved that our machine is totally different and there is no infringement at all, your lordships. Also, your lordships, the council seeks permission to highlight a case law, Standipac Private Limited versus MS Oswald Trading Co. Limited 1999. Yes, indeed, your lordship. Your lordship, it is in the document which is to be submitted right now to the bench, your lordships.
Have you mentioned the same in your written submission as a footnote?
Indeed, your lordships, it is.
What's the footnote number?
Your lordship, the council seeks permission to submit the report, your lordships. Your lordships, that an interim injunction should not be granted.
Council, please respond to me.
Indeed, your lordship.
What is the footnote number of your written submission? I'm pending for your footnote. Now you are submitting. I'm citing over here, I don't know how we will accept.
Indeed, your lordship, this is an additional submission made by us, your lordship. No, your lordships. Indeed, no, your lordships. Your lordships, that an interim injunction should not be granted when there is a serious question of validity of design, your lordships. Your lordships, the honorable bench must assess if patent can withstand such challenges, your lordships. Also, your lordships, in the case law of American Cinnamon Co. versus Ethicon Limited 1975, a principle has been established, that is threefold test, your lordships, and this particular principle has been included in many Indian case laws also, your lordships. The strong prima facie is required, which is failed by the appellant, your lordships. Your lordships, the council seeks permission to produce that particular report to the honorable bench, your lordship. Your lordship, in moot proposition para 8 and 9, Green Rotor Private Limited, a competitor, announced the launch of its own mixed base Crashmaster in August 2020, but the suit was initiated by the Planet Work in Jan 5, 2022, your lordships. Let the year be 1 or 2, delay in raising infringement claims by the appellant constitutes latches, your lordships, and also it constitute latches, and also it bars the injunctions, your lordships.
How does it constitute latches?
Your lordships, they have been waiting for almost 2 years after our machine was invented.
Is there any limitation period prescribed in the Patent Act?
Your lordships, the patent can be used for 20 years, but there is no actual limitation. But we are telling that there is an intention of the appellant, since their business has been moved to us nearly 5 years.
When there are no statutory limitation, why you are granting the court? If there is a time limitation, or would you like to connect with the limitation act is applicable for a patent claim?
Indeed, your lordships, we would say that the time period, which is of 2 years, they have been waiting till then.
No,
since
that's
our-
a
indeed,
delay
your
what
lordships.
fact says.
Indeed, your lordships.
Please substantiate to the bench.
Indeed, your
Is
lordships.
there any limitation period mentioned with respect to patent claim or
Indeed,
infringement?
your lordships, I request my researcher to assist me in answering that particular question, your lordships. Much obliged, your lordships. Your lordships, moving on to the second fold in addressing the issue 1, the doctrine of balance of convenience ensures that granting or refusing injunction does not unjustly harm any party, your lordships, and prevents irreparable injury that cannot be compensated by damages, your lordship. Your lordship, balance of convenience is not a mere formality, your lordships. It is safeguarded against undue hardship, your lordships. Your lordships, considering the critical role of Green Rotor in addressing the municipal waste crisis, even though it addresses several combination of wastes, here considering the critical role of Green Rotor in addressing the municipal waste crisis, the balance favors the continuation of sales, your lordships. Your lordships, a complete sale prohibition threatens essential harm to Green Rotor, including loss of goodwill, your lordships, market share, your lordships, and long-term business validity, your lordships. Your lordships, moving on to the third fold of issue 1, your lordships.
Balance of convenience?
Much obliged, your lordships.
Balance of convenience?
Indeed, your lordships, in balance of convenience, it ensures that the convenience of both the parties has to be considered before giving any order or solution, your
The
lordships.
other side lost 6 or 7 contracts.
Your lordships, just the Competition Act says, your lordships, I would like to, since the Honorable Bench has put forth such a question, I would like to move on to the Competition Act 2022 Section 4, prohibition of abuse of dominant position, Your Lordship.
Competition Act 2002.
Competition Act, indeed, pardon Your Lordship, it is Competition Act 2002 Section 4, prohibition of abuse of dominant position, Your Lordships. Also, Your Lordships, under Article 91G, everyone has a right of trade or business, Your Lordships, and mere losing of their clients. And also, Your Lordship, if you would see, in the moot proposition, it is clearly mentioned that 18% of economic saving, Your Lordships.
See, their product is patented.
Your Lordships,
Your product is not at all patented.
Your Lordships, mere,
Balance of convenience will fall into whose favor?
Your Lordships, mere patent.
Product is not at all
Indeed, Your Lordships. Indeed, Your Lordships. Your Lordships, in their perspective, patent means commercial advantage. Even when the appellant was arguing, they were only focusing on the commercial aspect, Your Lordships. We haven't focused because we need the environmental to be very clean, Your Lordships.
Counsel, my
Indeed, Your
brother
Lordships.
gets clarifications very direct.
Indeed, Your Lordships.
You made a list of the grounds for
Indeed, Your Lordships.
issuing an injunction.
Indeed, Your
Right?
Lordships.
The
Indeed,
second
Your
ground you made very categorically balance of
Lordships.
convenience.
Indeed, Your Lordships.
Now, Lordship clarification,
Indeed, Your Lordships.
how you will equate with the patented product with non-patented one.
Indeed, Your Lordships. Your Lordships, here the doctrine of balance of convenience, it has to balance both the parties, Your Lordships.
Who are in a equal footing.
Equal footing, Your Lordships.
Right. Are you in a equal footing?
Your Lordships, the mere patent doesn't mean that we are
My
not.
question is very direct,
Indeed,
Leonard
Your
Counsel.
Lordships.
You are
Indeed, Your
not,
Lordships.
right?
Indeed, Your
Then
Lordships.
where are the choices for you to demand which is available to the person
Indeed, Your
who are eligible to enjoy?
Indeed, Your Lordships, while addressing the issue 1, we are here to prove that the patent itself is invalid, Your Lordships.
Then no question of balance of convenience.
Indeed, Your Lordships.
What is the present position? Whether the patent is there or not?
The patent is available, Your Lordships, but the patent is invalid according to our contention, Your Lordships. We don't have any patent and probably,
It is only regarding injunction.
indeed, Your Lordships, even the Green Rodar, which is almost 20-year-old company, has taken its own time to get the patent, Your Lordships, but we are the young competitor and we are striving, Your Lordships, and we would be applying for the patent, Your Lordships.
Regarding the validity of the patent,
Indeed, Your Lordships.
on the we can decide later.
Indeed, Your
Now
Lordships.
is regarding the injunction and balance of convenience.
Indeed, Your Lordships.
As it is, their product is patented.
Indeed,
Your
Your Lordships.
product is not patented.
Indeed, Your Lordships.
Balance of convenience should go in his favor.
Indeed, Your Lordships, it is the responsibility of this honorable bench to see whether the patent used by them is for the public purpose or for only the commercial interest, Your Lordships. So that is the main concern here. And also, Your Lordship, the High Court has granted stay for the injunction, Your Lordships, and also that particular appellant company can continue their sale, Your Lordships. So their patent or their sales is nowhere.
Yes, Counsel. Clarification.
Indeed,
You
Your
made a
Lordships.
mention about fundamental freedom of trade and commerce. Is it available to the natural person? Is it available to the company?
Indeed, Your Lordships. Your Lordships, the Council seeks permission to read of the Article 19.
19(1)(g).
Indeed.
No
Indeed, Your Lordships.
citizen.
Practice any.
No, you start from 19(1).
Indeed.
No citizen.
Indeed, Your Lordships. Protection of certain rights regarding freedom of speech, etc.
No. You
One,
read only
all
19(1). Don't start with A.
Indeed.
19(1). No
Indeed.
citizen.
No, indeed, Your Lordships. All citizens shall have the right
Hmm.
to practice any profession or to carry on any occupation, trade, or business.
Is it for a person? Is it for a company?
Your Lordships, both company and the individuals, Your Lordships, company is an artificial person, Your Lordships. Indeed, Your Lordships. Your Lordships, moving on to the third fold, Your Lordships, the burden lies on the appellant to show irreparable damage, Your Lordships, and also the injury which is distinct from the compensable loss, Your Lordships. Your Lordships, there is no technical evidence or any expert chart or any report that has been submitted by the appellant to to demonstrate that the trash master has infringed the bioshredder, your lordships. Your lordships, moving on to the fourth fold of issue 1, your lordships, moot proposition para 8, your lordships. It is clear that the trash master was independently developed, as I highlighted before, your lordships, with inputs from German consultant. Your lordships, there is no infringement that has occurred, and the patent granted itself is in question, and it will be highlighted in issue 3, your lordships. Your lordships, the constitution under article 21 as interpreted in MC Mehta versus Union of India, your lordships, the council seeks permission to submit the report, your lordships, includes right to clean and healthy environment, your lordships. Fact para 1 and 2, your lordships.
Which MC Mehta council?
It is 1987, your lordships.
But which paragraph you read?
Your lordships, in document 3, it has been highlighted in the given report, your lordships.
There is a footnote.
Indeed, your lordships. Indeed, your lordships.
Absolute liability.
Indeed, your lordships.
Right environment.
Indeed, your lordships.
Read the paragraph. As a researcher, you can assist. Until he supplies, you can continue.
Indeed, your lordships. Your lordships, fact para 1 and 2, the rapid increase in plastic pollution calls for accessible advanced recycling technologies, your lordships. Our invention is such technology, your lordships. Your lordships, the TRIPS agreement, when coming to the international agreement, your lordships, TRIPS agreement, article 7 and 8 allows flexibility to protect public health and environmental goals over strict patent enforcement, your lordships. Your lordships, the principle of fiat justitia reat caelum. Your lordships, in the page 19 of the page 19 of our memo, your lordships, the constitution under article 21 as interpreted in MC Mehta versus Union of India 1987 includes right to clean and healthy environment, which is paramount, your lordships, and we have also submitted the judgment saying that right to clean environment is the vital part, your lordships. Your
NGO is concerned with the right to clean environment.
Your lordships.
In what way you are concerned with
Indeed, your lordships.
clean
Indeed, your lordships, it is responsibility.
They are marketing
Indeed, your
product.
lordships. Indeed,
You
your
are
lordships.
marketing your another product.
Indeed,
Is
your
it not?
lordships, but
Neither they nor you are concerned with clean environment.
Indeed, your lordships.
Both of you are concerned with marketing.
Indeed, your lordships. Your lordships, our company, beyond focusing on the commercial aspects, we also have responsibility towards the clean and healthy environment of the country of Aryavarta, your lordships. That is why we have reduced 18% of amount which the biostrata is given, your lordships, so that entire public can access, and that is also another question.
It may be a fair competition or unfair competition. It goes in that line. What
Indeed,
about
your
para 7? You are also promoting marketing materials.
Indeed, your lordships, being a company, we are advertising our product. And
Whether anywhere in the proposition, moot
Indeed, your
proposition,
lordships.
it is stated that the sole purpose of your
Indeed, your
product
lordships.
is, serving the society
Indeed, your lordships.
by
Your-
giving some apparatus regarding clean environment.
Indeed, your lordships, it is the responsibility of each and every individual, your lordships, and being an entity in Aryavarta. Yes, your lordships. Being an entity in Aryavarta, it is our role. Your lordships, being a company, it does not mean only profit, because your lordship, being a company, it doesn't mean that we should move only on the profit motive, your lordships. We also have responsibility towards the clean environment in the country of Aryavarta, which the company exists, your lordships. Your lordships, the principle of fiat justitia reat caelum, let justice be done though the heaven falls, your lordships, supports the equitable restraint, your lordships. Your lordships, if the bench is satisfied with the issue and the council seeks permission to move on to the issue 2. Much obliged, your lordships. Whether the trash master infringes the core claims of Planet Work Text Convention under the applicable laws of Aryavarta. Your lordships, the respondent respectfully submits before this Honorable Supreme Court that the trash master does not infringe the core claims, your lordships. Your lordships, again, the council seeks permission to address in 4 easy folds, your lordships. The first fold is patent claims, defines the exact legal boundary of the invention protection, your lordships. The claim must be interpreted according to their
an issue of patent claim, Learned Counsel?
Your
Which
lordships,
compromise, which page of the compromise you are connecting with?
your lordships, they were saying that we have infringed their product, your lordships. So we are saying that if we have infringed, then it is their burden of proof to say that we have infringed their
No,
product.
that's
your
what,
lordships.
already it was. Where is the question of claim?
Your
Reading,
lordships,
you are reading a line by saying what are the elements of a claim according to the act.
indeed,
Is
your
there
lordships,
any issue involved with respect to the claim of the
Indeed, your
learned
lordships.
appellants?
their experts have told that 3 out of 4 claims in the moot proposition has been infringed, your lordships. 3 out of 4 claims. We are asking what are those 4 claims, your lordships?
Regarding this burden of proof,
Indeed, your lordships.
relying on law of evidence, in the present general law of evidence, or the burden of provision in patent act.
Indeed, your lordships. Your lordships. Your lordships. Section 39 of BSA or the section 45 of Indian Evidence Act, your lordships. It talks about the expert opinion, your lordships. Here, your lordships, the expert opinion will not bind entirely.
Counsel,
your lordships, on
section
Indeed, your lordships.
section 45 of which year?
Your lordships, section 39 of BSA,
Ah.
Bharatiya Sakshi Adhinayam, and section 45 of Indian Evidence Act, your lordships.
Okay. Now you are referring 45 or 39?
We are referring 39, your lordships.
Okay.
Indeed, your lordships. Your lordships, section 104 also of BSA, your lordships, it transfers to other parties too, your lordships. The burden of proof, it transfers to the other parties
The
also, your
clarification needed by this court is
lordships. Indeed, your lordships.
whether there is any specific provision for burden of proof
Indeed, your lordships.
available in the Patent Act.
Indeed, your lordships.
Because when there is a general law and there is a special law,
Indeed, your lordships.
the provision in the special law will prevail over. So whether there is a provision for
Indeed,
burden
your
of proof,
lordships. It is
the patent.
104A of Patent Act, your
Yes,
lordships.
yes, you read that.
Indeed, your lordships. Your lordships, in the case law of Bayer Corporation versus Union of India 2009, the council seeks permission to submit the report. Your lordships, the claims.
Section 104A.
Indeed, your lordships. I request my researcher to assist, your lordships.
No, Lordship asked you to read. Why you are passing on?
Indeed, your lordships. Your lordships, the burden of proof in case of suits concerning infringement, your lordships, in any suit of infringement of a patent where the subject matter of patent is a process for obtaining a product, the court may direct the defendant to prove that the process used by him to obtain the product identical to the product of the patented process is different from the patented process if the subject matter of the patent is a process for obtaining a new product, or there is a substantial likelihood that the identical product is made by the process and the patentee or a person deriving title or interest in the patent from him has been unable through reasonable efforts to determine the process actually used, provided that the patentee or a person deriving title or interest in the patent from him first proves that the product is identical to the product directly obtained by the patented process, your lordships. Your lordships,
So it is primarily concerned with the process or product.
your lordships, the patent can be of both product or process, your lordships. If the appellant is claiming that we have infringed their process, or if they claim that we have infringed their product, the burden of proof lies on the appellant to prove the same, your lordships, because infringement has not been made by our company, your lordships.
Counsel, already you made a submission.
Indeed,
You
your
are
lordships.
not questioning the infringement.
Your lordships, our contention is there is no infringement, your lordships.
Then what is the point in making an argument whether you have a proof or it is shifted to them?
Indeed, your
You
lordships.
made a single line by saying
Indeed, your
we are
lordships.
questioning the grounds in which patent itself was confirmed.
Indeed, your lordships.
Right?
Indeed, your
then I think you can skip this.
Indeed.
Ah.
Much obliged, your lordships. Your lordships, I would like to go for a Gillen claim, your lordships. It is in the page number 159 of Patent Prosecution Book, your lordships, by Matthew Thomas. Indeed, your lordships, it says, which is against the patent infringement claim where the defendant claims that the product or process is already a prior art and therefore the patent itself is found on an invalidity, your lordships. This is also in line with the issue 3, your lordships. We are saying that the patent itself is invalid when there is a question of prior art, your lordships. The detailed explanation of it will be handled by my co-counsel in issue 3, and I assure that the counsel has answered the question already raised by this honorable bench, your lordships. Your lordships, the patent infringement in Aryavarta, which is parametria to India, your lordships, is determined by claim to product, your lordships. It is not product to product. We are saying that the claim itself is unclear from the appellant, your lordships. Your lordships, substance over form approach, your lordships. It should not stop new solutions or it should not penalize improvements, your lordships. Designing around a patent is lawful, your lordships, even desirable, your lordships. Your lordships, the council seeks permission to quote legal maxim expressio unius est exclusio alterium, your lordships. The expression of one is the exclusion of another, your lordships. Only what is claimed is protected, your lordships. The scope cannot be expanded to broader connection. Your lordship, the council seeks permission to conclude the issue 2, your lordship, saying that we conclude with this immortal wisdom from the revered Tirkural, your lordships, which reminds us of the fundamental principle அவற்றிடமும் நடந்து அஞ்சாமை ஒருவருக்கு நாட்டும் பிழைத்து நின்று. Your lordship, one who walks without fear among all is conqueror of land itself, your lordship. May this honorable court, walking fearlessly on the path of justice and equity, recognize the truth in our submissions and affirm fair competition and innovation for the progress of Aryavarta, your lordships, and also for the progress of our own company, your lordships. If the bench is satisfied with issues 1 and 2, I request my co-counsel to present with issues 3 to 5, your lordships. Much obliged, your lordships. It was privilege and honor arguing before this honorable bench, your lordships. Much obliged, your lordships.
Council seeks permission to approach the bench. Much obliged, your lordship. Warm greetings, your lordship. Warm greetings, your lordship. The council seeks permission to address the bench collectively as your lordship. Much obliged, your lordship. If the lordships permit, the council may proceed with issue number 3. Much obliged, your lordship. Your lordships, the issue number 3 before this honorable court is whether the patent granted to the Planet Works is valid and enforceable in the view of counterclaim for revocation filed by the Green Rotor, your lordship. Your lordship, it is humbly submitted before this honorable court of Aryavarta. The patent granted to the Planet Works Tech is not valid and not enforceable in the view of counterclaim being filed filed by the revocation for by the Green Rotor, your lordship. Why? Because, your lordship, there is a lack of statutory criteria under the Patent Act, your lordship. The Patent Act granted to the Planet Tech work is under section 64. There is a lack of grounds in section 64, your lordship. The grounds of invalidity of patent is under section 64 includes lack of novelty, lack of inventive steps.
Whether there is any provision for counterclaim in the Patent Act?
Indeed, your lordship.
What about that provision?
Indeed, your
What
lordship.
does the provision says regarding the grounds for counterclaim?
Indeed, your lordship.
5 minutes. How much time she finished? Then why are showing only 5 minutes?
Indeed, your lordship. Your lordship, the council will answer for this question in our further arguments, your lordship.
15 minutes to them.
No, you are arguing on
Show 5 because
three.
then they will face.
Indeed, your lordship. Indeed, your lordship.
So Patent Act
Indeed, your lordship.
says that
Indeed, your lordship.
circumstances
Your lordship, section
there can be a
66.
counterclaim. So you being arguing in this point,
Indeed,
how
your
to say
lordship.
that
Indeed, your
these
lordship.
grounds you are relying on?
Indeed, your lordship. Indeed, your lordship. Your Lordship, Section 66 of the Patent Act provides for revocation of patent in public interest, Your Lordship, as it is the ground provides for the revocation of patent in the public justice. The green rota, that is, the defendant is filed for revocation of petitions, Your Lordship.
That is for revocation.
Indeed, Your Lordship.
Revocation can be claimed in many circumstances.
Indeed, Your
Not
Lordship.
only in counter claim.
Indeed, Your Lordship.
As far as revocation of patent is concerned,
Indeed,
many
Your Lordship.
circumstances it can be claimed.
No, you made a 3 compartment of arguments.
Indeed, Your Lordship.
One is counterclaim,
Indeed, Your
second
Lordship.
one is revocation,
Indeed, Your
third
Lordship.
one is invalidity to confirm the patent.
Indeed, Your Lordship.
Which stand you are going to take?
Your Lordship, first of all, I am going to take the grounds under Section 64, Your Lordship.
What
Your
section
Lordship-
64 say?
Section 64 gives for the grounds for invalidated the patent, Your Lordship.
Right. Now
Your
you
Lordship-
list out of 3 elements of a patent,
Indeed, Your
which
Lordship.
element is not
Indeed, Your
fulfilled by the learned appellant.
Indeed, Your Lordship. Your Lordship, the grounds are first of all the lack of novelty and lack of inventive steps under Section 2, JA, and non-patentable subject matter under Section 3, and wrongful procurement and non-compliance with the information disclosure requirements under Section 8 of the Patent Act, Your Lordship. Your Lordship, the first contentions that Your Lordship, the core conditions of the patentability under Section 2 Clause 1J and 2 Clause 1JA is that, Your Lordship, invention must be new and not obvious, Your Lordship. Your Lordship, Section 2.1J provides for invention, and in the meantime, Section 2.1JA provides for inventive
Which
steps.
made you learned counsel for respondents say their patented product lacks the novelty.
Indeed, Your Lordship. Your Lordship, that these provisions, the mentioned provisions provides that, Your Lordship, the invention must be new, Your Lordship. Your
That's what the provision says. How you are going to substantiate
Indeed,
by
Your
saying
Lordship.
it is
Indeed,
not
Your
now?
Lordship. Indeed, Your Lordship. Your Lordship, there are prior art and public knowledge reveals that the process of apparatus steps, Your Lordships. The council seeks permission to submit the reports, which is reveals there is already existence of the patentable machines like bioshader machines, Your Lordship. Indeed, Your Lordship. Your Lordship, before the bioshader machines, there are several plastic waste recycling machines, Your Lordship.
Was there
which
any opposition applications were made? Have you heard of opposition procedures?
Pardon, Your Lordship.
Have you heard of opposition procedure to grant a patent?
Indeed, Your Lordship.
Which section of the Act says?
Pardon, Your Lordship.
Which section of the Act, Patent Act 1970 says, if there is no novelty, anyone can make an application for opposition?
Indeed, Your Lordship. Your Lordship, Section 2 Clause T provides for the person interested, Your Lordship. The persons who are interested in the patent matter may claim for the challenges of these patent, Your Lordship. Grounds for validity, Your Lordship.
Okay, continue.
Your Lordship, in the provided document 2 and 4 and 5, patent number US 8393562 B1, which is granted in 2013, Your Lordship, and also US 2008 in 2018 there is a patent machines which is publication number 0015477A1, Your Lordship, which discloses the machinery and methods for disposal and recycling the mixed plastics and without pre-sorting the wastage, Your Lordship, which resembles the process and the procedures and the inventive steps which is closely relevant to the bioshader machines, Your Lordship. And Your Lordship, the machines in India which is parametria to the Aryavarta, such as also used such as a machine WPPM called as waste plastic product machines, Your Lordship, which is a technology operational before 2019 itself, Your Lordship, in especially in Maharashtra, processed all types of plastic including a mixed waste and using a semi-automated and thermal mechanical steps also, Your Lordship. And these patents and models shows that systems comparable and functionable equivalent with the bioshader and the alleged infringement innovations were not only publicly known and also being protected by the patent, Your Lordship. And Your Lordship, thus anticipation destroys the novelty, Your Lordship. And Your Lordship, when we go... Indeed, Your Lordship.
Developed a machine capable of directly converting mixed grade plastic
Indeed, Your Lordship.
Any prior art is in this area, directly it is to convert
Indeed, Your Lordship.
the mixed grade plastics into reusable granules.
Indeed, Your Lordship.
You have narrated so many
Indeed, Your Lordship.
statements.
Indeed, Your
Whether
Lordship.
that invention
Your Lordship, on submitted documents.
Not simply, dealing with the waste plastic. That waste plastic must be dealt with in such a way that the machine should have the capability of directly converting
Indeed, Your Lordship.
grade plastics into reusable granules.
Indeed, Your Lordship.
So the granules must be immediately
This
reusable.
process is already exists, Your Lordship.
That's what.
Indeed, Your Lordship. Indeed, Your Lordship.
This one.
Indeed, Your Lordship. Your Lordship, the submitted document number 2, patent which is provided in 2013 US, Your Lordship, which is using a process steps including a depolymerization method and melting and mechanical separations and cooling it and given to a granules, Your Lordship, and this. Indeed, Your Lordship.
Finally, in giving granules,
Indeed, Your Lordship.
result,
Indeed, Your Lordship.
process is heating and everything.
Indeed, Your
Or
Lordship.
it is
Indeed, Your Lordship. Indeed, Your
Whether
Lordship.
granules are reusable granules or only granules.
Indeed, Your Lordship, but indeed, Your Lordship, this report is very silent about whether it is reusable or usable, Your Lordship. But the inventions behind the machine is to be reusable only, Your Lordship.
We cannot presume. Here it is very clear.
Your Lordship,
Granules are
Your
reusable.
Lordship, if these granules are not to be reusable, and then the processing and the innovations of machine is failure, Your Lordship, and there is no technology and use of times and use of investing money and in the technology to be resulted very in failure, Your Lordship.
The appellant is very clear.
Indeed, Your
Their
Lordship.
claim
Indeed, Your Lordship.
or their fencing.
Indeed, Your Lordship.
Reusable granules.
Indeed, Your Lordship.
Whether there is any difference between
Indeed, Your
granules
Lordship.
and reusable.
Indeed, Your Lordship. Indeed, Your Lordship. As our reports suggested that, Your Lordship.
Two types of pens.
Indeed, Your
One
Lordship.
pen is you can use and use a drop.
Indeed, Your Lordship.
Another pen is reusable.
Indeed, Your Lordship.
When you say that there is a pen, you
Indeed,
cannot
Your
say that it is a reusable pen.
Indeed, Your Lordship.
Just like that.
Indeed, Your
This is
Lordship.
reusable granules.
Indeed, Your Lordship. Your Lordship, the machine which is mentioned in the document number 5, machines which is existed in India itself, Your Lordship, in Maharashtra, processed all types of plastics including a mixture and using semi-automated and thermal mechanical steps, Your Lordship. And these thermal mechanical steps is very closely relevant to the bioshutter machines, Your Lordship. Indeed, Your Lordship. Your Lordship, when we come into the grounds of patents, which falls under the non-patentable subject matter, the Section 3F of the Patent Act 1970 clearly states that, Your Lordship, the mere arrangement or rearrangement or duplication of known device, each functioning independently of one another is in a known way, is not an invention and hence not patentable, Your Lordship. And the so-called bioshutter machines combines a known mechanical systems as pre-existing technologies without any novel independent synergy, Your Lordship. And Your Lordship, in Manivandan versus IPAB, which is cited as Petition number 11951 of 2011, Your Lordship, the court have reaffirmed that, Your Lordship, simply bringing together known components would not grant for new inventions, Your Lordship. And Your Lordship, when we come into the Section 3D of the Patent Act, excludes the mere discovery of a new form of a known substance or mere use of a known process unless it is results in a new product or employs at least one of the new reactant, Your Lordship. Your Lordship, the bioshutter does not introduce any fundamentally new process or results, nor it employs any new reactant to, Your Lordship. It is essentially reuses existing plastic recycling steps which is already involved and which is proved through the documents which is already get patent to, Your Lordship. And Your Lordship, Section 3B of the Patent Act 1970 provides for injury to the public order or to the environment, Your Lordship. The inventions shall not be granted for patent which could cause a serious prejudice to the environment, Your Lordship. The patent for the bioshutter fails to demonstrate actual environment benefits or safeguards, Your Lordship. Instead, the commercial proliferation of thermal-based plastic recycling machines which can contribute to the emission and require strong environmental scrutiny also, Your Lordship. And your lordship, the patent law is based on quid pro quo, your lordship. The exclusive right only exchange for the genuine progress or public disclosure, your lordship. And the public interest is not served by granting or maintaining over or unfinished monopolies, invalid patents, harm the innovation and the public welfare, your lordship.
What is section 3B?
Section 3B
You read slowly, please.
Indeed, your lordship. Your lordship, section 3B provides for injury to public order or to the environment, your lordship. If any patentable machines which is injury to the public order or environment, it will not be promoted, your lordship, by
Okay.
the... Indeed,
Now,
your lordship. Indeed, your lordship.
The other side, they have invented an apparatus
Indeed, your lordship.
that is going to clean
Indeed,
the
your lordship.
environment,
Indeed, your lordship.
and that is going to make
Your lordship,
reusable granules. Is
Indeed,
not?
your lordship.
In what way you apply that
Indeed, your lordship.
with section 3B?
Indeed, your lordship. Your lordship, they are being used as thermal-based machines, plastic recycling machines. It will cause the emissions also, your lordship, which will also affect the environment, your lordship. By saying merely we are protecting environment through the machines, we could not promote another way of
which emissions?
affecting, your lordship.
Where is it there in the proposition?
Your lordship, it is mentioned in the moot proposition that they follow the thermal-based plastic recycling machines, your lordship. As we know, and we know that, your lordship, by using a thermal machines causes the heat and the emissions to, your lordship, like a carbon which combines a carbon dioxide and also a sulfuric acid to, your lordship. Much obliged, your lordship. Your lordship, issue number 4 before this honorable court is whether the intervention of an NGO in a patent infringement is maintainable, your lordship. It is humbly submitted before this honorable court. It is humbly submitted that, your lordship, intervention of an NGO in a patent infringement is maintainable, your lordship, as because, your lordship, section 25 of the Patent Act 1970 especially allows any persons to file a pre and post grant opposition against a patent application on various grounds, your lordship. It is indeed, your lordship.
Any interested person can exhaust section 25 of Patent Act. Is it
Indeed,
in
your
the
lordship.
Supreme Court or is
Indeed,
it
your
in a
lordship.
any
Indeed,
specific
your
court?
lordship. It is a fact which is being silented in the moot proposition, your lordship, as it is.
Read section 25
indeed,
of the Patent Act and answer.
Indeed, your lordship. Your lordship, 25 of the Patent Act, especially for 25 clause 1 provides for pre-grant opposition and 25 clause 2 provides for post-grant opposition, your
Where?
lordship.
Is it in a Supreme Court or in any specific forum?
No, your lordship. Before the controller, your lordship.
Okay, now you are here where?
Indeed, your lordship, we are taking this provision as an instance and to show the legislative intent of the parliament, your lordship, which reflect the legislative intent to encourage a wide public participation in a patent examination, your lordship. Why? Because, your lordship, these pre and post grant opposition may be filed by any persons, which is expressly provided in the section 25 itself, your lordship.
Have you exhausted with the controller of patent? Have you exhausted the same section before the controller of patent?
Indeed, your lordship.
When?
Your lordship, it is being silented in the moot facts. We are
That's
saying
a statement
we
you
are
have to say. After saying yes, then now you are saying it's silent. Continue.
indeed, your lordship. Indeed, your lordship.
Participation at what stage?
Okay, continue.
Indeed, your lordship. Indeed, your lordship. By permitting any person, including NGO, to object to patents, ensure transparency, checks against frivolous and overbroad patent claims, and safeguards the public interest, this participatory aligns with the principles of administrative fairness and democratic accountability, your lordship. And your lordship, the person interested is being defined in section 2T, and which describes who may be the deemed party to the proceeding concerning the infringement and revocation, your lordship. Section 2, clause 1, clause 3 of the Act provides for person interested as someone engaged in or promoting research or trade related to the patented inventions limited to the filed stakeholders directly affected economically and innovative by the patent, your lordship. And section 64, while deals with the revocation, and 104 deals with the remedies for infringement, specifies the action only by the person interested, your lordship. underscoring the legislature's intent to restrict participation to those with the concerned states, Your Lordship. And also, Your Lordship, when we come to the CPC, under Order 1 and Rule 10, expressly allows any person to intervene in a suit who claims have an interest in the same subject matter of the litigations. The rule is wide and not merely restricted, Your Lordship.
Intervention of NGO
Indeed, Your Lordship.
is in the nature of public interest litigation.
Indeed, Your Lordship.
Public interest
Your
litigation.
Lordship,
So there is a litigation, private litigation in between you and them.
indeed, Your Lordship. Indeed,
It
Your
is section 1, article 136 of the
Indeed, Your Lordship. Your Lordship,
SLP.
Your Lordship, it is
So that
being.
public interest litigation can be filed through article 136 of the Constitution of India.
Indeed, Your Lordship.
Other public interest litigation can be filed in some others.
Indeed, Your Lordship. Your Lordship, the Patent Act itself, while promoting a monopoly and commercial interest to one party, and also deals with the public interest and participation of public to Your Lordship. For an example, it is evident from the provision 83 and 84, which provides for the compulsory licensing, which is in the interest of public interest, Your Lordship. And Your Lordship, it also encourages any person to interfere while the pre and post granting, which is already contention by this
That's
council, Your
what the
Lordship.
learned counsel for the appellant categorically mentioned.
Indeed, Your Lordship.
Since there are statutory power conferred to you, NGO, without exhausting, you simply pleaded in the Supreme Court. What was your interest? Was it the public interest? Was it the private interest? What is the
Indeed, Your Lordship.
profit interest?
Your Lordship, there is no profit or name frame motive for NGO, Your Lordship. It is purely of the environment, Your
which prevent your socially responsible NGO not to exhaust with the register of patent or any trial judiciary where you can exhaust these two, either infringement or revocation.
Indeed, Your Lordship.
Do you have any data you have attempted or you haven't attempted?
Your Lordship, as it is evident from the moot proportion itself, Your Lordship, yeah, the First Foundation is an NGO, is an environmental NGO, Your Lordship, has filed their intervention petitions in the patent.
Counsel, that's a compromise.
Indeed, Your Lordship.
You read the sections from the Patent Act.
Indeed, Your Lordship.
You can oppose at the first stage, section 25, pre and post with the registrar.
Indeed, Your Lordship.
Then you can initiate the proceedings for a revocation.
Indeed, Your Lordship.
Section 64.
Indeed, Your Lordship.
Without exhausting, which made you to approach the Supreme Court exhausting Article 136. That is a specific question by the learned appellants. What is your answer?
Your Lordship, the petitioners invoked 136, Your Lordship. Council 6 extra time for
Yes, we
question.
will be.
Indeed, Your Lordship. Your Lordship, the petition is being filed by the appellant under 136 from the decision of the High Court, Your Lordship. We come into the intervention IA through the intervention applications under Order 1 and Rule 10 in the capacity of the public interest on the environmental concerns, Your Lordship.
Which
And
CPC?
CPC.
Whether
Order
CPC is
1,
applicable to Article 136? Whether CPC is applicable to Article
Indeed, Your Lordship.
136?
Indeed, Your Lordship. It
Could
is
you,
applicable, Your
could you,
Lordship.
could you cite any substantial decision given by the court?
Your
Don't
Lordship.
you give original side rules of Supreme Court and High Courts?
Indeed, Your Lordship.
Okay, go to issue number 5. Final issue.
Indeed, Your Lordship. Your Lordship, the final issue before this honorable court is whether granting or enforcing exclusive patent right infringes the constitutional right to a clean and healthy environment and breaches the international environmental covenants, Your Lordship. It is humbly submitted before this honorable court that, Your Lordship, granting and enforcing exclusive patent right in a sector like critical to environment preservations like waste management technology and fundamentally infringes upon the constitutional right to a clean and healthy environment and breaches the international environmental covenants, Your Lordship.
Which article says you have a right to environment?
Your Lordship.
Which constitutional article say you have a right to environment?
Your Lordship, Article 21, which
Please
provides.
Please read Article 21.
Your Lordship, Article 21 provides for life and personal right to.
Read. No person shall be
Your Lordship,
deprived.
no person shall be deprived of his life and personal liberty except according to procedure established by law. Your
Where is
Lordship.
Environment Council?
Your Lordship, it is not expressly provided, Your Lordship, but it is already dealt by this Honorable Supreme Court and passes a number of cases, Your Lordship.
Where?
Your Lordship, in Subhash Kumar versus Union of Bihar, it is held that Your Lordship.
Subhash Kumar versus State of Bihar. Not Union of Bihar. Okay, what does
Your
it say?
Lordship, Subhash Kumar was the state of Bihar, Your Lordship. The citation number AIR 1991, Supreme Court page number 420, Your Lordship. It was held that, Your Lordship, the Article 21, right to life, and life includes the right to a clean and healthy environment, Your Lordship. It is
You read correctly. Right to clean, healthy and potable drinking
Yes.
water, that's all.
Indeed, Your Lordship.
Where is
Indeed, Your Lordship.
environment?
Indeed, Your Lordship. Your Lordship, merely.
Where is Environment Council?
Your
It
Lordship,
says right to
environment
clean,
not
healthy
only.
and potable drinking water.
Your Lordship, environment is not dependent, Your Lordship. It is independent with the natural resources like water, air, and so many things, Your Lordship.
Is it
As-
you learned council definition, or do we have a definition for environment in India?
Pardon, Your Lordship.
You mentioned water includes environment.
Indeed, Your
Is it
Lordship.
a learned council's definition?
No,
Are
Your
there any
Lordship.
definition
No,
for
Your
envi-
Lordship.
Ah.
No, Your Lordship. It is not a single council's definition, Your Lordship. As the Environment Act, umbrella legislation also says the same definitions, Your Lordship.
Where? You substance.
Your Lordship, section 2, Your Lordship, 2A, it
Ah.
defines it as environment, Your Lordship. Environment includes the water, land, and air, and so many things, Your Lordship.
Okay. Then what international instrument says right to environment is?
Your Lordship,
fundamental?
instrument of environment covenants like Rio Declaration and TRIPS agreements and
TRIPS agreement. Which article of TRIPS agreement speaks about environment?
Your Lordship, TRIPS agreement provides for sustainable development, Your Lordship. While dealing with the technology, it should be balanced with the sustainable development. Your sustainable development is nothing but, Your Lordship, the technologies must.
Which article of TRIPS speak about sustainable development?
Your Lordship, section Article 10 of. Sorry, apologies, Your Lordship. Article 27, Clause 2, Your Lordship,
What does it
allows exceptions to patentability on environment and public health grounds, Your Lordship. And Your Lordship, Article 31 and 39 provides for compulsory licensing and safeguard undisclosed informations also, Your Lordship. As Article 27, Clause 2 explicitly provides for environment and public health grounds, it will not be affected by granting an exclusive right to a single company, Your Lordship.
Where is sustainable development?
Your Lordship, sustainable development should not attain by granting an exclusive patent to a single company, Your Lordship. Why? Because, Your Lordship, as being a single entity, being a single company, they would not met over to the whole nation's need, Your Lordship. As Aryavarta is already faces so many of environmental issues and also in providing for nearly 20% of global mixed waste, Your Lordship. The sustainable development should be achieved only through the public encouragement and checks and balances between the technologies and the environment, public use, Your Lordship.
Okay, go to your prayer.
Indeed, Your Lordship. Your Lordship, with the due permission of the court, the council seeks permission to the. With the due permissions of the court, the council go up to the prayer. Your Lordship, wherefore, in the light of the facts and arguments and issues raised and authorities cited, the respondent most humbly prayed and implored before this Honorable Supreme Court of Aryavarta may please to allow the counterclaim for revocation and declare the patent granted to the Planet is valid and unenforceable, and hold that the patent specifications does not comply with the disclosure requirements under Section 10 of the Patent Act and revoke the patent on grounds of lack of novelty.
Is valid or invalid?
Your Lordship?
Patent given is valid or invalid?
Invalid, Your Lordship.
You better valid.
Invalid. Apologies, Your Lordship. Invalid and revoke the patent on the grounds of lack of novelty and lack of inventive steps and insufficient disclosures and wrongful obtainment under Section 64 and 66 of the Patent Act 1970 and dismiss the patent infringement suit filed by the Planet Works Tech with cost and vacate any injunctions or interim relief granted to the Planet Tech and also pass any such other order or further orders as this Honorable Court may deem fit in the interest of justice, equity, good conscience and constitutional guarantees. And for this act of kindness, the respondent shall duty to bound forever to pray, Your Lordship. Your Lordship, it is our privilege and honor to argue before this honorable bench today, Your Lordship. Indeed, Your Lordship.
Already you have exceeded time, so therefore for you only 3 minutes of surrender. Okay, you can take 5 minutes. So don't repeat, you are very specific. Okay, so whatever you listen from the last
points and then rebut, your lordships. Lordships, firstly, onus of proof or the burden of proof was argued, your lordships. It was argued that the burden of proof is on the appellant because the respondents were not infringing the patented article. My submission is that, your lordship, even if there is no infringement, your lordship, in a patent infringement case, the court has to decide whether the infringement is present or not in the instant case, and only the court would fix the burden of proof. Second, your lordship, it was argued that the appellant company did not do anything for a very long time, but the facts mentions that in October 2021, a cease and desist notice alleging infringement was served to the respondents, your lordships. Thirdly, market share, loss of goodwill, all these things were argued, your lordships, but in the instant case, all these argument holds no value, your lordship. The infringement has to be proved and the grounds under revocation has to be cited, your lordships. Your lordships, Article 19(1)(g) was argued, your lordships. Lordships, Article 19(1)(g) is certainly not for the furtherance of infringing the patent rights, your lordship. A valid patent rights cannot be infringed under Article 19(1)(g), and it shall also be noted that the Article 19(1)(g) is not absolute, your lordships. Furthermore, opposition to the patent under Section 25 of the Patent Act was argued, your lordships. Section 25 subclass 1 of the Patent Act very clearly stipulates that everything is before the grant, your lordships. This is a post-grant challenge. When it is a post-grant challenge, contrarily Section 25 subclass 2 very clearly holds that within 1 year of the grant of patent, your lordship, the complaint has to be filed to the controller of patents in a very appropriate manner, which is not present in the instant case. Your lordships, in order to in the instant case, the revocation filed is a counterclaim. It's not a standalone claim, your lordships. Counterclaim is filed to the district court, your lordships. Section 25 was argued not for the counterclaim of revocation, your lordships. Section 25 subclass 2 says that within 1 year of the grant of patent, complaint can be filed to the any interested person can file the complaint to the controller of the patents in an appropriate manner. The section is very explicit, your lordships. In order to prove the novelty, some nameless company from the Maharashtra was taken, your lordships. Your lordships, there are no reports to authenticate it, and it is a third party who is not involved in the instant case, your lordships. Furthermore, prior art was argued, your lordships. Prior art from Germany. It is a very wrongful argument, your lordships, because we have overcome all those prior art allegations in order to obtain the patent. On the other hand, in the Aryavada itself, there is a prior art that is biosreader. There is a very clear prior art to the Trashmaster, your lordship. It is a mere discovery. Furthermore, your lordship, in order to prove revocation, counterclaim for revocation was repeatedly argued, your lordships, but not even a single ground under Article 64 was cited for the process, for the legal process. Furthermore, the most important point to note is that, your lordship, there were repeated arguments about the configuration of the machine, where the facts is silent, your lordship. The configuration of the machine cannot be argued based on the assumption, your lordship. It will mislead the court in a very wrong way, your lordships. Furthermore, the counsels appeared for the respondents, your lordships. Novelty was argued, infringement was argued, your lordships. Suddenly, then in the next minute, environment was argued, your lordship. Land, water, air. And then the social responsibility was argued, and suddenly the next minute commercial interest was argued, your lordships. The question that I put before myself is that whether the respondents are appearing for the NGO or for the company. Is it for the furtherance of the environment, or is it for the mere business commercial interest, your lordship? That has to be clarified. And your lordships, we do not rely on the onus of proof, your lordship. We did not make any submissions regarding the burden of proof. We have clearly proved the validity of the patent, and we have proved the clear case of infringement, your lordships. I'll have to answer 3 questions that your lordship. Only one clarification, your lordship. The intention while arguing is to run through your lordships in a very fast manner, whatever in the written submission, to argue everything before your lordship. That's the aim. And the aim is not to argue anything out of the written submission. Thank you.
appellant submitted almost 2.5 years, your lordships, but it is almost 1 year, which is also a time gap, your lordships. And also, your lordships, when we were talking about Article 19(1)(g), as we did not infringe anything and proved before this court via arguments and reports saying that it is our right to business, and we being the young competitor, we refer that particular article, your lordships.
It's your freedom to, not right.
It is our freedom indeed, your lordships. And also, your lordships, the prior on affidavit were from the experts, your lordships, and we were contending on the experts saying that there is no binding of the expert opinion, your lordships. And also, your lordships, we cited nearly many grounds under the sections of 64, your lordships, where the learned counsel failed to appreciate it, your lordships. And also, your lordships, the thermal process was mentioned in the moot proposition, and we were just referring to that particular thermal process, your lordships. And also, your lordships, the land, water, all were related to the different issues, your lordships. So, our content was to the issue 4, issue 5, your lordships. So, we were referring to the different issues, and the learned counsel confused with the issues 4 and 5 with our arguments, your lordships. And it was much pleasure clearing the giving the clarifications for the issues raised by the learned counsel, your lordships. Much obliged, your lordships.